It is too important to remain limited to discussion on an executive judiciary conflict. There are really important issues of constitutional law and theory that are raised as a consequence of the judgment, and we hope during the course of the evening to be touching on some of those. We are really fortunate to have an excellent panel of distinguished luminaries with us today. Starting from my right, Mr. Raju Ramachandran, senior advocate and one of the foremost authorities on constitutional law, particularly incisive writings on the basic structure doctrine, on which we'll be hearing him today. Mr. Arvind Datar, who represented one of the petitioners in the Supreme Court, so is a victor as far as this case is concerned, and we'll hear from him particularly about the composition of the NJAC and why it was so problematic. On my left, Mr. Ganguly, senior advocate, and also an amicus curiae in a matter called Suras India, which many of you might know, some might not, which was one of the first matters where the Supreme Court doubted the validity of the collegium and asked for reforms. So we'll hear from him about judicial independence and what the consequences of the understanding of judicial independence are as far as our judgment is concerned. And finally, we have Madhav Khosla. Madhav is the author of the Oxford Introduction to the Constitution of India and has written extensively on constitutional law. And we'll be hearing from him particularly on the rather knotty issue of how the collegium can be reformed. So we want to discuss issues of constitutional law and theory today. And in the interests of full disclosure, as I've done a thesis on judicial independence and accountability and support the NJAC and assisted the Union of India in this matter. So without any further ado, the format that we'll follow is that the speakers will make their opening remarks for 8 minutes on the basic structure, the judicial independence, composition of the NJAC and reform of the collegium. Then we'll have a moderated discussion for the remaining period of time. So ladies and gentlemen, thank you once again for coming. And I hand over to Mr. Ramachandran to start us off with questions as far as the basic structure doctrine are concerned, and specifically how the court has interpreted the basic structure and what it means for constitutional law and theory. Thanks very much.
Thank you, Arno, and thank you all for coming. When we talk of the basic structure, we need to think of 4 professions: architecture, civil engineering, masonry, and bricklaying. And my point is going to be that this judgment has brought us to the bricklayer as against the architect and the civil engineer, which Keshavananda Bharati had in mind. Now, what precisely has been held to be part of the basic structure in the NJAC judgment? Independence of the judiciary, of course, because both sides proceeded on that assumption that independence of the judiciary is part of the basic structure. Though interestingly, you will find that in the illustrative examples given in Keshavananda Bharati, Justice Khanna, who says possibly judicial review, there was no talk of independence of judiciary because the assault on the independence of judiciary started after Keshavananda Bharati. Now this judgment, and when I say this judgment, I obviously mean the majority, it proceeds on a blinkered view of what independence of judiciary means, because it sees independence of the judiciary as only independence from the political executive. It has not seen independence of the judiciary in terms of a fair and impartial judiciary generally. And so, because this judgment sees independence of judiciary in these narrow terms of independence from political interference alone, when it says the appointment process is part of independence of the judiciary, which it no doubt is, it still sees the appointment process as one which needs to be insulated not just from political interference but even political participation. Any kind of outside participation, not domination, not executive domination, not civil society domination, but participation is seen as affecting the basic structure. Now, in my submission, this is normatively indefensible because independence of the judiciary is not just independence from the political executive, but independence from the influence of corporate houses, independence from the influence of lawyers, law firms, independence from the career interests of the kith and kin of judges, and independence from judges' own predilections, prejudices, etc. And if this be the true meaning of independence, then there has to be an element of outside participation, but because the court has seen it only in terms of independence from the political executive, the judgment, in my submission, is flawed. There has to be independence from nepotism, from their own arbitrariness, from the arbitrariness of judges, casteism, and independence from mindsets and worldviews which are inconsistent with constitutional values. Now, primacy is taken as an essential part, primacy of the judiciary in the appointment process is seen as an essential brick in the structure. And this primacy is also understood as an overwhelming majority. Judicial primacy means an overwhelming majority. It is not enough for the majority that institutional primacy has been given in the NJAC. Why do I say institutional primacy? Because out of 6, if the judiciary as a block has 3, as against 1 of the executive and 2 of civil society, institutional primacy is given to the judiciary, but that doesn't seem to be enough. And that's why I started by saying we are now getting into bricks and cement. If the color of the brick is different, that itself seems, in the view of the majority, to affect the basic structure. Now, what are the implications of this judgment for the future of the basic structure doctrine. Now, all these years, I have of course been a critic of this doctrine, but that's not the point. We are proceeding on the basis that basic structure doctrine is law of the land. In the years which have passed since Keshavananda Bharati, there has been a certain conservatism in the application of the basic structure doctrine, as you can see from the relatively few number of constitution amendments which have been struck down over the years. But after this judgment, I see a change in the future in the application of the doctrine. Earlier, and I think most of you are either lawyers or law students, legal scholars, or those interested in the law, the approach of the court had been some overarching principle needs to be violated for there to be a violation of the basic structure. But now, by looking for components, by looking for bricks, the approach is going to change. It's not just going to be overarching, but individual elements are going to be scrutinized, and especially in matters concerning the independence of the judiciary. Please remember, there's a judgment of the Supreme Court of 1990, not often noticed, Delhi Judicial Service Association, where the Supreme Court has held that Articles 136 and 142 of the Constitution are also part of the basic structure. Now, I see a lot of flowering and creativity as far as basic structure jurisprudence is concerned, just as you have seen the growth of derived fundamental rights for the benefit of the citizen in the post 77 era. Now you are going to see lots of basic structure derivatives, and that is my fear as a critic of the doctrine of basic structure. Thank you.
Thank you, Mr. Ramachandran. I think some excellent opening remarks, especially on whether judicial primacy is part of the basic structure. What's the basis for the judgment to say that primacy is part of the basic structure and participation of any other organ is violative of it? That's something that we will discuss. And about the future of the basic structure, as in what